Hello and welcome. I'm Steven Vaughan. I'm a professor in the Faculty of Laws at University College London, and I'm here this evening representing OutLaws, which is the faculty's LGBT+ staff student network. Delighted you could join us for this talk by Alan Briddick. I'll do a proper introduction of Alan in a moment, but let me explain how tonight is going to unfold. We will have a talk from Alan for around 30-40 minutes. There is then plenty of time for questions and comments. Strongly encourage you to use the Q&A box, which I'm sure you're all very familiar with, having spent this last year online via Zoom. So do please put any queries, comments into the Q&A. Feel free to do that either as Alan is talking or when we get to the end of Alan's talk, where I say we've got lots of space to have a discussion with him. I'm really excited about this talk, a very powerful, very important topic. You can tell how excited I am by the fact that I'm wearing a tie for, I think, the third time in the last 12 months, still wearing slippers, but wearing a tie. Alan is a barrister at One Pump Court. He was a former partner at Blake Morgan LLP. He has a very broad practice covering immigration, asylum, modern slavery, human rights and public law. He was a former trustee of the Lesbian and Gay Immigration Group and a founding member of the Trans Equality Legal Initiative. He's published in the Birkbeck Law Review on LGBT asylum issues, and I saw he was shortlisted this year for the Chamber's UK Award on Diversity and Inclusion. I also see from Twitter that Alan is a Schitt's Creek fan, which makes me like him even more. Really delighted to have you here this evening, Alan. Very grateful you give up your time during LGBT History Month for this talk. I will load your slides up now and then hand over to you to begin whenever you're ready.
Thank you, Steve. Thank you very much for that lovely introduction. Thank you. So next slide, please, Stephen. Right, so welcome everybody. In 2010, the Supreme Court changed the lives of two gay men known as HJ and HT, finding they were not obliged to conceal their sexuality in their home countries, Iran and Cameroon. In the seminal case known as HJ, the Supreme Court found that expecting gay men, and by analogy, all queer people, to conceal their sexuality or gender identity to avoid persecution was not a correct interpretation of the Refugee Convention. The courts below the Supreme Court had found that the Refugee Convention requires concealment of sexuality where that is reasonably tolerable. Now, in one of the most famous parts of the judgment, Lord Roger said, and I'm going to read it in full, "In short, what is protected is the applicant's right to live freely and openly as a gay man. That involves a wide spectrum of conduct, going well beyond conduct designed to attract sexual partners and maintain relationships with them. To illustrate the point with trivial, stereotypical examples from British society, just as male heterosexuals are free to enjoy themselves playing rugby, drinking beer, and talking about girls with their mates, so male homosexuals are to be free to enjoy themselves going to Kylie concerts, drinking exotically colored cocktails, and talking about boys with their straight female friends. In other words, gay men are to be as free as their straight equivalents in the society concerned to live their lives in the way that is natural to them as gay men without the fear of persecution." Now, although Lord Roger pointed out that this is a trivial, stereotypical example and goes to the heart of what the Supreme Court found in HJ, that a gay man is just as entitled to be open about his sexuality in whatever form that takes as a straight man is, and that must also apply in other societies. The next slide. Let me give you a little bit of background. The drafters of the Refugee Convention did not envisage that claims could be made on the basis of sexual orientation and gender identity. The first time that sexuality was found by a court to come under the convention was by a Dutch court, and that's the first case I have in the slide. In the UK, it was 8 years later in the second case that I have in the slide. And it was on that case, the Shah and Islam case, that sexuality was recognized as a particular social group for the first time. However, these cases provided little protection for lesbian, gay, and queer people, however, as the UK and other contracting states of the Convention around the world adopted a test known as the reasonable degree of tolerance test. In other words, hide yourselves. Queer refugees were under a positive obligation to avoid persecution by concealing their queerness, if they could, in Australia until 2003, in the UK, as I've just said, until 2010, and in most member states of the European Union until 2013, following the case of XYZ. Next slide. In HJ, Lord Roger set out a 4-stage test to see whether a person is a refugee on the basis of sexuality. And it's a lengthy test. It goes through another slide as well. So I'm going to paraphrase it. First, is the person lesbian, gay, or bisexual, or queer? Second, would lesbian, gay, bisexual people who lived in their country, who lived openly in their country, be liable to persecution there? Third, what would the person actually do? Would they live openly, or would they conceal their sexuality? Next slide. And fourth, if they would conceal, why would they conceal? If a material reason for concealing is fear of persecution, then as long as the other parts of the test are met, the person is a refugee. If not, and the person conceals for other reasons, simply for other reasons, such as family pressure, the person is not a refugee. Now, personally, I will never understand how a person from a country where they would be persecuted, if they were open about their sexuality, could conceal only for personal reasons, but that is for another day. In my opinion, the 4-stage test and HJ in general is being misapplied by governments, the UK government and other governments that followed it. This misapplication has brought with it a new wave of stereotyping, and decision makers assess claims at best from a Western perspective of how queer people should behave and live their lives, and at worst actively discriminates against queer refugees who don't conform to the Western ideal of queer people. People of color, women, people from religious backgrounds, people who may not be out and proud about their sexuality or gender identity, people who are not financially independent, to give just a few examples, are frequently denied refugee status because of those characteristics. Each individual part of the person's identity or social situation which marginalizes them not only makes it harder for them to be recognized as refugees, but are actively used against those people to refuse them refugee status. Let's take Lord Roger's test in turn. First, is the person lesbian, gay, or bisexual? Next slide, please, Stephen. When the UK government and other governments around the world were no longer to refuse refugee status due to the reasonable tolerance test, they started refusing on grounds or credibility or disbelief. That was set out by Milbank in her article, From Discretion to Disbelief. Brazil and Ireland say the main challenge identified in the literature on SOGI applicants in Ireland relates to credibility. Following HJ, the government rushed to Stereotypes to refuse claims. You don't look like a lesbian. You could not be gay because you do not know who Oscar Wilde is. You don't sound gay. You are not promiscuous. You had a relationship with the opposite sex, are all real reasons that claims were refused in the UK. Arzugula says, decision makers are confronted with the risk of falling into their own biases. The identity of the decision maker might be more decisive than the identity of the applicant. Next slide, please, Stephen. To give but one example, and this is directly from a determination in the UK. And again, I'll read it in full. Although Miss M has a slightly mannish appearance, I place no real weight on that in determining whether she is reasonably likely to be lesbian, if only because, A, that slightly mannish appearance was substantially attributable to the manner in which her hair was cut and the fact she wore no brackets or very little makeup, and to a degree, her age brackets, she's now 39 years old. The manner in which Miss M's hair was cut and her appearance are obviously very much matters over which she has substantial control. And Miss M is not a large, muscular or well-built woman, but on the contrary is slightly built, so that her appearance is not striking. And since her claim to asylum is based on the contention that she is a lesbian, it would not be surprising if, whether or not she is in reality a lesbian, she would take steps to ensure at the hearing of her appeal, her appearance was consistent with her claim. I pause for a moment to let you take that in. A masterclass of homophobia and misogyny in one short paragraph. In 2014, the then Chief Inspector of the Home Office, John Vine, published a report, an investigation into the Home Office's handling of asylum claims made on the grounds of sexual orientation. His first recommendation to the Home Office was that it improves training so that stereotyping and stereotypical expectations of LGB activity and lifestyle do not appear in interview questions. The Home Office did act on the recommendations of the Chief Inspector of the Home Office, and there is no doubt that it is better now, but arguably more problematic, because what has crept in is a new type of stereotyping, more subtle and harder to challenge, but stereotyping nevertheless, and this again affects marginalized persons even more. So when a queer person presents themselves to the government for refugee status, the government rightly looks to the HJ test and asks itself, first, is this person queer? And as the burden of proof rests with the refugee, the person has to prove their sexuality or their gender identity. And the government expects them to do so in a stereotyped one-size-fits-all manner. Do you have a partner? Do you have sexual partners? Where are your LGBT friends? Do you go to gay bars? Do you attend LGBT groups? And where are your pictures of pride? If the person has all those attributes, they stand a far higher chance of their sexuality being accepted. But what if they don't? What if they don't have a partner? They don't have any gay friends or any friends? Will their claim be accepted? Much less likely. Let's take an example of two people, and these are two real people, obviously with different names. John is a gay man from Russia. He is white. He had a good job in Russia and was able to come to the UK with a decent amount of money. He immersed himself in the UK queer scene as soon as he got here. He likes to go to bars and clubs, and he did march in Pride. He has many friends. He has one ex-partner and several previous sexual partners, all of whom are willing to give evidence on his behalf. Sandra is from Uganda. She is Black. She is a woman. She is a lesbian. She came to the UK with virtually no money, and she is reliant on the Ugandan diaspora in the UK for casually paid work and her accommodation. She is an extremely quiet and shy person. She suffers from mental health difficulties, partly because she was the victim of so-called corrective rape in Uganda. Sandra is marginalized because she is a woman. She is marginalized because she is Black. She's marginalized because she's a lesbian, because she's an asylum seeker, because she has no money, because she has mental health difficulties, and because she is the victim of gender-based violence. You can see that by comparing John and Sandra, how marginalization makes it more difficult for Sandra to prove her claim, which will be decided on Western stereotypes. But even if Sandra wanted to or was able to, she cannot go to LGBT bars, etc., as she doesn't have any money. As a result, she doesn't have a partner. She doesn't have any gay friends. So what does she have to prove her sexuality? Well, she has her word. And of course, that makes it far more difficult for her to be believed. The government will then ask Sandra questions to see if they can accept her word. And this is where even more stereotyping creeps in. The government will expect Sandra to have an eureka moment when she realizes she is a lesbian. They may even expect her to give a date. They will expect her to have felt different and maybe shame. Now, she may have, and perhaps most LGBT people do. But what if Sandra doesn't? What if Sandra only realized she is gay after she came to the UK? Or she doesn't even know now? With her lack of evidence, there's a significant chance that Sandra will be disbelieved and denied the refugee status that she is entitled to. Sandra was denied refugee status because she didn't have lesbian friends, or no friends, or any friends, no partner, and she didn't go to bars or groups. She was marginalized. Further, she didn't meet the stereotyped expectation of coming to terms with her sexuality. So we can see that governments base their decision on a Western view of what an LGBT person should be. They should have a binary sexuality. They should be out and proud. They should like gay bars. They should go to Pride. They should be promiscuous. And if they don't fit into that stereotype, how could they be gay? Sadly, the more marginalized the person is, the more likely it is that their sexuality will not be accepted. Next slide, please, Stephen. Stereotyping is far from just a problem in the UK. In the case known as ABC, the Court of Justice of the European Union noted that the Dutch authorities refused to accept the self-declared sexuality of a refugee. And as the court recorded, the authorities rejected B's application on the ground that the statements concerning his homosexuality were vague, perfunctory, and implausible. In addition, insomuch as B is from a country where homosexuality is not accepted, he ought to have been able to give more details about his emotions and his internal awareness of his sexual orientation. And the court noted, while questions based on stereotype notions may be a useful element at the disposal of competent authorities for the purposes of the assessment of applications for the grant of refugee status on the basis solely of stereotypical notions associated with homosexuals does not, nevertheless, satisfy the requirements of the provisions referred to, in that it does not allow those authorities to take account of the individual situation and personal circumstances of the applicant for asylum concerned. Who knew we needed the Court of Justice of the European Union to tell us that? Next slide, please, Stephen. In an Irish case, a gay man was found not to be gay on the basis that he liked on Twitter a video of heterosexual pornography. The tribunal found that if someone views heterosexual porn and then clearly indicates their approval of such material, then it is reasonable to assume, on the balance of probabilities, that such a person is a heterosexual. Furthermore, if a homosexual person was interested in viewing porn, then it is reasonable to assume such porn would be homosexual. Brazil and Ireland report that the High Court in Ireland rejected the applicant's complaint that this decision as to his homosexuality was based on a certain stereotype of the assessor and was in breach of the CJEU decision in ABC. But the Western stereotype doesn't stop there. Let's have a look at the rest of Lord Rogers' test. First, would a gay person who lived openly be at risk of persecution? And why would a person conceal? I take these two together because they become inseparable from what amounts to persecution and what are merely social mores. What openly means is again a question for another day. But for the purpose of this talk, I am taking it to mean that the person will tell people or reveal their sexuality, such as not hiding they live with a partner, not changing the gender of the partner in conversation, perhaps flirting with a person of the same sex, or drinking exotically colored cocktails and talking about Kylie or Katie Lang to keep to the stereotype. Next slide, please, Stephen. There have been 9 country guidance cases concerning sexuality in the UK since 2010, and none of them concerning gender identity. Excluding SD Turkey, which was not concerned with risk generally in Turkey. Not one of these cases found there is a generalized risk to gay men or women due to their sexuality in their home countries, despite the criminalization of sexuality in most of the countries concerned and widespread non-acceptance of non-heterosexual sexuality in all of them. How did the tribunal reach its conclusions? In my view, they were based on stereotypes and again, the marginalization of queer people in those countries. Not only that, there is a return to concealment. Next slide. In OO Algeria, the 2016 one, the tribunal found where a gay man remains living with his family to whom he has disclosed his sexual orientation in circumstances where they are prepared to tolerate that, his decision to live discreetly and to conceal his homosexuality outside the family home is not taken to avoid persecution, but to avoid shame or disrespect being brought upon his family. That means that he has chosen to live discreetly, not to avoid persecution, but for reasons that do not give rise to international protection. Note the language, prepared to tolerate, to avoid shame and disrespect. This is not just an individual's case. This is what the tribunal found to be the case for all gay men in Algeria. It went on to find, quite apart from that, an Algerian man who has a settled preference for same-sex relationships may well continue to entertain doubts as to his sexuality and not to regard himself as a gay man in any event. Are we to compare to a gay man in the UK? Are there no gay men or women in the UK who may entertain doubts as to their sexuality? Or is it uniquely Algerian? Or is it just foreign? Of course, that might be true in individual cases, as it is in the UK, but how can all gay men in one country be deemed to have these doubts? No thought seems to have been given to the fact that maybe these doubts, if they are so widespread, stem from fear of persecution, or at least on the basis that it is entirely unacceptable to be openly gay in Algeria. Chicken and egg. Next slide, please, Stephen. But the tribunal wasn't finished with its stereotypes yet. It went on to say, because there is general adherence to strict Islamic doctrine, which includes a similar intolerance of extramarital sexual relations, young married men do not have access to women and so may have to resort to same-sex liaisons. This is not seen as homosexual conduct, but pragmatism in achieving sexual gratification. Indeed, there is some evidence that where one of the same-sex partner is perceived to be dominant, he will be admired as virile and masculine. This decision is based on stereotypes, not just stereotypes of gay men, but as stereotypes of an Islamic-based country. It is true, of course, that Algeria is a predominantly Muslim country, and it is true that homosexuality is not accepted there. But the tribunal found there is no risk of persecution for openly gay men to live in Algeria because of those stereotypes. The stereotype of the doubting gay man, the stereotype that men have sex with men in Islamic countries because of, in the tribunal's words, lack of access to women. The stereotype that men will have sex with other men, or in the words of the tribunal, resort to sex with other men for sexual gratification and pragmatism. And the stereotype that if one sexual partner is dominant, he will be admired as virile and masculine. Next slide, please, Stephen. In SW Jamaica, the tribunal found not all lesbians are at risk. Those who are naturally discreet, have children, and are willing to present a heterosexual narrative for family or societal reasons may live as discreet lesbians without persecutory risk, provided they are not doing so out of fear. How can we separate that out? What is a naturally discreet lesbian in a country where lesbians who are open about their sexuality are at risk of persecution? Why might they be willing to present a heterosexual narrative only for family or societal reasons, when in fact, if they didn't, they would be harmed? Next slide. Likewise, in LH and IP Sri Lanka, The present appellants maintained a very low profile in terms of their sexuality in the UK. Only a few close friends are aware. In Sri Lanka, they would also choose to live discreetly because that is what they prefer, and due to social pressure, such as not wishing to distress their parents or embarrass their friends. Next slide. This is flawed, and for a number of reasons amounts to reverse covering. Covering is what the person might do in their home country to conceal their sexuality, such as hiding traits and mannerisms, for example. Then they are expected to reverse that in the host state, as LH and IP were in the Sri Lankan case. This is best explained by Bezzeri in their article, Gay and Lesbian Asylum Seekers in the United States, the interplay of sexual orientation, identity development, reverse covering, and mental health. Reverse covering is the opposite of covering and refers to being pressured into acting or dressing according to stereotyped ideas of one's identity. LG asylum seekers are caught having to play out both covering and reverse covering. When applying for asylum, they must reverse cover so as to prove their sexual orientation to judges by enacting stereotypes of lesbian and gay individuals in order to make this identity status visible. Bezzeri goes on to say, one of the problems with the reverse covering demand by immigration judges is that there is the expectation that lesbian and gay asylum seekers will automatically be open about their sexual orientation and come out immediately once they arrive in the United States. So looking again at LP and IP, the tribunal did not address the actual reasons why the individuals were not out and proud in the UK as the expectation was. This couple came from a country where their sexuality is criminalized and there's virtually no societal acceptance of same-sex relationships. Although some people who come from such a society might be able to live completely openly in the UK, it's not realistic to expect everyone who comes from such a country to suddenly live openly. The Western stereotype of the out and proud gay man marching in pride rears its head again. Second, the wrong question was asked. The question is not why they would choose to conceal their sexuality in the UK, but rather, is fear of persecution a material reason why they would conceal in sexuality? Third, do they conceal their sexuality in the UK? They are a couple living together. They tell friends, even if just a few. Do they lie about their sexuality to their landlord, for example? The tribunal didn't ask. Not only did the tribunal, in this case and many others, ask itself the wrong question, but it has confused and conflated privacy with concealment. Some people are more private than others with any aspect of their lives. A queer person has the same right to be private than anyone else without losing the right to refugee status. Sandra was also refused refugee status for this reason, in the alternative that she is not gay. The tribunal found she is gay, but dismissed the appeal for these reasons. Next slide, please, Stephen. All this evidence indicates that the appellant has chosen to live a very private and discreet life in the UK. She has done so. She has done so even though she could have lived more openly, and even though she could have revealed her feelings to friends. This was her choice about the way she wanted to live in the UK. If she chose to live in such a way in an open society where she is not at risk, she would live the same way in Uganda, and I find she would live discreetly there. Apart again from asking the wrong question, the tribunal is confusing concealment with privacy, and the tribunal has not taken into account why she is private or even why she may conceal in the UK. She did not choose to keep her sexuality secret in the UK. She would have lost her lodgings and livelihood if she didn't. Another real example is Edward, again, a different name. Edward is a Jamaican gay man. Edward was brought to the UK as a child by his mother. His mother suspected he is gay and would insult him for not being manly enough. Age 15, she would buy him condoms for him to have sex with girls. She threw him out of the family home when he was age 15 and he was forced to live with foster parents. Like Sandra, he was an extremely private person about his sexuality, perhaps for obvious reasons. Consider how Edward was marginalized. He is gay. He is a person of color. He has no legal status. His mother rejected him for not conforming to her idea of masculinity. He was in foster care. He had no way of looking after himself and later had to fend for himself as a very young man. His claim was refused on the basis that the way he lived in the UK meant that he would conceal his sexuality in Jamaica for his own reasons. The tribunal even accepted that he is a private person. The tribunal found, next slide please, Stephen, his delay in claiming asylum and raising the issue of sexuality very much ties in with the evidence before me, pointing to the appellant being an extremely private person, loath to discuss or to publicize his private affairs and reticent about disclosing his sexuality. Again, the wrong question was asked. But not just that, look at these stereotypes. I find nothing in the evidence before me to point to his involvement with the LGBT community in the UK, or to show his having made friends within that community, and to show him in any way publicly identifying himself as a gay man. The evidence demonstrated the appellant has himself chosen to live a discreet gay life here and conducts his affairs with discretion and privacy. I find that would be his position in Jamaica. Publicly identifying himself as a gay man in the host member state is not a requirement of the Refugee Convention. The marginalization of Edward, based on a Western ideal of what a gay man should be, out and proud and publicly declaring himself, was the reason his claim was refused. He was refused refugee status because he was marginalized and because of Western stereotypes of what a gay man should be. He was also refused, of course, on a gross misapplication of the HJ-Iran test. Next slide, please, Stephen. You may have noticed that I've concentrated on sexuality so far. The principle in HJ that gay men should not be obliged to conceal their sexuality clearly applies to gender identity, indeed as it does to other immutable characteristics such as religion. However, in my opinion, it cannot be applied directly, in particular, Lord Rogers' four-stage test. In this case, MXM, the upper tribunal found that a non-binary identity can form the basis of an asylum claim. No question, I agree with that. But then the tribunal went on to apply the four-stage test. In that case, the tribunal accepted that the individual would not conceal their gender identity, so the tribunal did not have to ask the why question. But how could that person, or a trans person, conceal their gender identity in the way envisaged by the Supreme Court that gay men could? Lord Roger considered how a gay man might live discreetly. He said, "It is convenient to use a phrase such as acting or behaving discreetly to describe what the applicant would do to avoid persecution. But in truth, he could do various things. To take a few examples, at the most extreme, he might live a life of complete celibacy. Alternatively, he might form relationships only within a circle of acquaintances who he could trust not to reveal to others that he had gay relationships. Or he might have a gay partner, but never live with them, or have him to stay overnight or indulge in any display of affection in public. Or the applicant might only have fleeting anonymous sexual contacts as a safe opportunity presented itself." How could a person express their gender identity discreetly? A gay man can, for example, go to the shop to buy a pint of milk without necessarily revealing his sexuality and without necessarily hiding his identity. But what would, say, a trans man do? How could he go to the shop discreetly? He would have to pretend to be a woman. In other words, living discreetly would be confined in private places at all times. He could never be himself in public. He would have to conceal his gender identity entirely. In my opinion, therefore, the fourth stage of Lord Rogers' test does not apply to gender identity. Next slide, please, Stephen. So how do we resolve this? How should governments decide whether a person is queer? Well, first, self-identification should be the starting point. Second, do not disbelieve unless there's a reason to disbelieve. Third, do not impose stereotypes. Do not expect LGBT people to look the same, talk the same, feel the same, and have the same history. Fourth, do not assume that persecution is merely adhering to social mores or not wanting to upset our mothers. If I could finish where I started and say that although Lord Roger is absolutely right, that if a gay man wants to drink exotically colored cocktails and listen to Kylie, he has the right to do that without fear of harm. But I've no doubt that Lord Roger did not envisage that gay men in perverse reverse covering would be expected to do so. If the government asked my advice, I would tell them, we are not clones, we are queer.
Thank you, Ellen. What a very powerful talk, also very painful. It was wasn't very easy to listen to, but so important that those sorts of very hard issues get made more public. And I remember, I don't know if you remember this, the reason I originally reached out to you, I saw you tweeting screenshots of some of the cases you'd been involved with, and I remember seeing the tweets. I think it may well be in the Manish screenshot you showed us earlier, and I just couldn't quite believe that a tribunal judge was saying that. I thought it must have been wrong. I thought it must have, I thought it must have been incorrect. It must have been, from somewhere else. So thank you for sharing that with us. I won't abuse my position as chair. I've scribbled down, 1,700 questions, but I can see some questions in the chat, which I'll go through now, and would encourage those who are listening to also pop additional questions into the chat. So let me start off with this first question from Olivia, which is about the Equality and Human Rights Commission. So Olivia says, the EHRC must take the government to task for not applying equality impact assessments that would highlight the potential risk of segmenting people on biases, discrimination and stereotypes, sexual orientation and gender identity and race, including asylum seekers and refugees, are covered under the Equality Act. And my question is why the government hasn't been challenged for its failure to observe the Act. What do you make of that? Big question.
Yes, it's a very big question, and I think I agree, and it's perhaps even wider than that. The UK government, the current government, and the last May government, and every government at least since Blair, has declared the UK is the best place to be queer and LGBT in the world, and they say it's fantastic. We have this, we have that. Aren't we great? But those standards are not applied to refugees or other people, queer people. It's a truism of refugee law that a person cannot expect necessarily the same standard in the host country. That doesn't make them a refugee if the standards aren't as good in their country. But you very often see in refusals and in judicial decisions really just undercutting the rights that a gay, lesbian, transgender person has in the UK, and nullifying them and saying we shouldn't have those at all, or just misunderstanding that queer people are also people too and want to live their lives. I see, for example, in some cases where maybe a lesbian from Malaysia, and they'll say, oh, it's all fine in Malaysia because there's a gay sauna in Kuala Lumpur. Well, my client doesn't want to live in a sauna in Kuala Lumpur. She wants to walk down the street without fear of harm. So I think it's a really good question and goes even wider than the Equality Act.
There are at least three questions in the chat about bisexuality. And let me start off with Anya's question. Have you found the extent of stereotyping varies according to the sexuality of the person applying for asylum? I'm thinking particularly of bisexual people, especially as you've mentioned doubting and the requirement for a binary sexuality, but I'm also interested in various between gay men and lesbians. And so Nina then says, my gut instinct with bisexual asylum seekers is they are inherently believed even less.
Yeah, that's absolutely right. And that's 100% right. And unfortunately, there are some legal advisors that I've come across, I've had clients where I've been told by my client that they were told not to say they're bisexual. Now, I can see the reason behind that, because the Home Office doesn't believe anyone, and definitely doesn't believe bisexuals. And the fact that with the woman and vice versa will just immediately ring alarm bells in the Home Office. And I think it is a lot more difficult for bisexual people, but people without a binary sexuality, to persuade the Home Office. You know, for example, with some of the processes that they ask the person to explain, such as the realization of sexuality. There's been a study from Australia, an Australia-Canadian study, saying, well, that actually really doesn't apply to women. It might apply a bit more to men, but doesn't apply to women at all. So when they're asking someone to have this binary view, not just are you a lesbian, are you a gay man, but, you know, when did you realize, when did you kiss that girl, when did you kiss that boy? And it's yeah, if it's not straight down the line, pardon the pun, then they will have difficulties with it. It's a really, really good question. You know, talking about gender as well, and they don't actually, the Home Office doesn't refuse many trans cases on credibility. So they refuse so many cases of gay men and bisexual, gay men and women, etc., on credibility, but it's relatively rare that they refuse a person on gender identity. But they still really don't understand that identity that the person is. So I certainly have seen, like with bisexuals, for example, you know, why can't you just go back and be a straight man or a straight woman? But also, with say a transgender person, if that person does want to have some kind of medical intervention, for example, but hasn't had that, then the tribunal, the Home Office and the tribunal really struggle with that, because they see gender to be binary. So yeah, anything that's outside the binary is going to be more difficult.
And I'm going to chip in here. I mean, that's the way in which these issues are perceived, the way in which they're understood. That was what one of the things going through my head as you were speaking. I'm kind of curious now, I found it really interesting in your talk, you were referencing lots of studies. There was lots of kind of data points in your talk. Is that what you do when you're before the tribunal? So if the tribunal is trying to come to a view about sexuality in Algeria or Malaysia or wherever else it is, and you're an advocate for a client, how is it that you try and get the tribunal to a particular place? Do you come armed with, you know, 50 studies here which explain what it means to be a lesbian in Malaysia? Like, how do you try and convince the tribunal about conditions in certain places?
Gosh, yeah, that is a really good question. And like, you know, I always think that there's kind of different, I haven't thought about it too carefully in relation to groupings, but there are different groupings of countries. So if, you know, if you're from Uganda, if you're from Saudi Arabia, if you're from Iran, you know, there's some countries that's it. There's no question. If you are a queer person, you'll be accepted as a refugee, as long as the fourth stage is met. But then there's the countries that aren't quite as bad. So, you know, I mentioned Malaysia or Tanzania, and then bizarrely Bangladesh. So, you know, if you're from Pakistan, that's accepted that gay men and women can't live in Pakistan openly. But it's not accepted from Bangladesh, but probably the country materials are worse actually for Bangladesh. So, you know, if it's from a country that is less well known for LGBT abuses, then certainly a lot of research has to go into that to try and find reports. And it can be difficult because it's a dichotomy that the more afraid that queer individuals are to be out, then the less incidents of violence against them will be, because they're afraid to be out. And that's very, very, very true of the Algerian cases. Most definitely in a case where there's some kind of crossover between identities or even perceived identities. So for example, I did a case for a transgender man from Tanzania, but that was his case. But I also argued on the basis that he would be perceived as a lesbian woman in Tanzania. So yeah, you have to kind of like think about how to present that person's identity to the tribunal. And sometimes, I wouldn't say hostile tribunal, but ignorant tribunal maybe. And I don't mean that in a pejorative way, I mean that in the literal way. Just sometimes you get an ignorant tribunal, but it's hard.
That was my other, I'm generally interested in judges and, broadly judicial ideology, how judges exercise their discretion. I'm guessing that the tribunal judges, the sort of cases you take aren't everyday cases, so they might not necessarily have a lot of expertise or experience with these sorts of issues. Do you tend to see and kind of hope for certain tribunal judges when you have a case coming up? Do you tend to see, do you know, for example, any LGBT plus tribunal judges who you think may be more or less sympathetic or more or less, we've all heard Lady Hale talk about how being a feminist and a woman, gave her a certain an appreciation of certain types of cases. Do you see any of that going on?
Definitely. So, in terms of hoping to get a different judge, then yes, like sometimes you turn up and you're like, oh my goodness, what are we going to do now? Feign a heart attack. And other times you're delighted. But, they are quite, the judges generally, the management of the judges, I suppose, they're not that bad. They do take active steps to try and understand. I was invited into one of the hearing centres to speak about these issues, and they were very open. And there were actually some judges there that were very open that they were gay and lesbian, and they talked about those issues. But again, like sometimes there's a proposal put forward, oh, they should only have lesbian, gay men, or bisexual people judging these cases. But that's not a good idea either, because, well, who are we to judge? You don't know, just because someone is gay or lesbian themselves or bisexual doesn't mean they can automatically tell someone else and might think, oh, I've got a very good gaydar, I can tell that they're not a lesbian or whatever. So it's difficult. I think generally the tribunals and the courts, I think generally in the UK, they are open to getting to doing it right. And if you look, for example, at the Equal Treatment Bench Book, which covers all the different characteristics from the Equality Act and more, and the sections on sexual orientation and gender identity in the Equal Treatment Bench Books are quite good. So going back maybe to your other question, sometimes I go on with that and say, oh, look what you're being told to do. You're being told to do this and you're being told to do that, and don't make assumptions and don't make stereotypes. And that's obviously a good source to go from.
And it's kind of pleasing. I remember studying criminal law in the 1990s at university, and I very clearly remember being a young gay man. There was something in the Equal Treatment Bench Book at that point reminding judges that you couldn't catch HIV from kissing, and it's kind of it's very positive to hear that actually advances have been made, in terms of judicial education and training. And when you were kind of talking then about kind of giving the tribunal members benefit of the doubt, Tom has a question in the chat on that, which says, how do you think the UK in general does compared to other countries when it comes to these sorts of cases? Are we leading the way or are we lagging behind?
Again, that's a really good question I don't know the answer to. You can compare it to, I can read some literature. I can see actually that someone I quoted in my talk is on this call, and I think is asked for a question in relation to the situation in Ireland. So, if there's literature out there, you can read it. And, for example, there was a big conference last year organized by Sojica, which was a University of Sussex program looking at LGBT refugees in 3 different countries in the European Union. And people came from all over Europe to talk about their experiences with working with LGBTQ refugees, lawyers and social workers, etc. And so you got a better sense of what was going on. My guess is we're kind of in the middle, I would say. I would say that's kind of in the middle. I don't think it's that bad. I think they do try. There's certainly rogue elements. But unfortunately, and this is perhaps quite political thing it is a political thing to say, but right now, it may start at a hostile environment. Patel is lighting fire to it. And, I can see that rhetoric going down to decision makers and the way in which cases are dealt with. So, you've got that as well. It's not just, it might be a queer refugee, but there's also, you're a refugee, you came on a boat maybe or something. So, those things are all interlinked. But yeah, I would say maybe somewhere in the middle, my own stereotyping thinking that the Nordic countries are perfect, but they also sometimes produce pretty hideous results as well.
On kind of politics, Nick has a question about political utility. I'm going to read it out because it's a long question, but it's a really interesting one. You said that if refugees are more active on the scene once they arrive, you gave examples, joining Pride, going to gay bars, they're more likely to be accepted as queer. Do you think the judgment as to whether the person is queer or not is then based on how useful the person is in a political sense? Usefulness in this context being the extent to which the person who's from a demonstrably politically hostile country in terms of acceptance of sexuality is willing to promote the more favorable values of sexuality of their adoptive country. And Nick says maybe they're being overly cynical, but do you think the extent to which a refugee can help to shed a favorable light on those in power, I guess here in the UK, may form part of their likelihood to be accepted for asylum?
Wow, there's a question. I'm not sure if I would say it goes up to the higher echelons of power, but what you say definitely comes across in decision making, and including by judges. Oh, the UK is a fantastic country, thank you so much. That's going to go somewhere. And it reminds me again, at that Sojika conference last year, there was a person who gave a talk from Finland, and I can't remember their name, to be honest, but they gave a talk about, they were a social worker, and they talked about the fact that the social workers would receive the LGBT migrant and would be like, oh, you've arrived in nirvana, and you can cast away your previous life, and this is how you have to be. And what the person was saying is that it's almost like that was validating the social workers, so they were trying to help the person, there's no question about that, but they also were imposing this, isn't Finland the best country ever, and you've arrived, you're safe now, and aren't we great? So I'm not sure, Nick, if it goes up the higher echelons, again, with this particular government and the government we've had for a long time now with the hostile environment, but it's definitely a thing, there's no doubt about that. And you remind me a little bit actually of the fact that I told you about the reasonable tolerance test that the Supreme Court did away with in HJ Iran. That test was defended by the government, and the government at the time was the Labour government. So the Labour government said that gay people should go back and hide themselves. Yeah, not a particularly good look when that was at that kind of hyper advancement of LGBT rights in the UK.
No, yeah, very disappointing. I'm gonna a couple more questions, and I think we might draw this to a close. Although we could go on for hours given the wealth of questions in the chat. So Nina has a really interesting question about evidence and proof, and asks: is there a standard of question that is considered unacceptable or inappropriate? There is an outlawing of the submission of explicit materials, but I've heard from people being asked extremely intimate questions about their sexual experiences.
Yeah, so the Court of Justice of the European Union has outlawed not just asking for sexually explicit material, but even taking sexual explicit material, because it goes against the dignity of the individual. Mm-hmm. Before that report that I talked about in 2004, the Home Office in the UK, they were accepting sexually explicit material, which what happened was that kind of word went round that you have to bring a pornographic video with you to your asylum interview. So, feeling the need to do that is obviously not very good for one's dignity. So that is completely outlawed. The also is the sexual preferences as well. The CJEU has also outlawed that as well. And again, the UK government is quite good at that. Perhaps it's gone to the other extreme. So, in an interview, they don't want to know what the person did with their first girlfriend or boyfriend, but sometimes the person just wants to kind of describe the scene or something. And they're like, oh no, we'll stop you there, we'll stop you there. So it might have gone a little bit too far. If people are being asked intimate sexual questions about intimate sexual things, that should not be happening.
Mm-hmm. Question from Tom about kind of generational change, I guess. So Tom says, is there a particular challenge for the next generation of queers who don't feel the shame of previous generations? I look at my nieces and nephews at school. where queer identities are celebrated and accepted in ways which they were not in the past?
Gosh, yeah, there is the difference that the Home Office expects. If somebody rocks up and says, no, I'm afraid I don't want to be killed, but I don't feel shame, etc. I think that there's no doubt. I've seen many refusals on that basis. You didn't explain this realization, and you didn't feel these negative emotions. Sure, I think it's likely that maybe even the vast majority of people at the moment coming from countries where one will be persecuted because of sexuality or gender identity may have gone through those emotions. I hope Tom is right that new generations won't feel that. If the government apply its current policy, then there's a big possibility that the younger generation could be refused because they don't share perhaps other generations' negative emotions about their sexuality.
So Trish says, Alan, thanks for such a fascinating presentation. In terms of the ongoing role of discretion-based reasoning, based on the questionable notion of entirely voluntary discretion in homophobic societies, decision makers also fail to take into account that the closet can be a very unsafe place. Even if a person can be said to voluntarily choose to be discreet, how can they be safe from the potential that others will nonetheless perceive them as LGBT+ and the risk of persecution that might then arise?
Yeah, absolutely. There's no question that arises a lot, and also not just that, but you're looking at a moment. So the time when the individual has made their asylum claim is whatever, 2021. They might be young or just discovered their sexuality or gender identity or whatever. And even if that person says, I will not tell anyone ever about my sexuality, I'm too ashamed, I don't want to upset my mother, and all the rest of it. But what happens in 2 years' time when they change their mind, or when they meet somebody? Then they have to lie about the meeting someone. So it's very much a kind of a snapshot in time of what that person is at the moment. If you can show that you wouldn't be able to conceal your sexuality or gender identity, and there's a risk of harm, then the why questions shouldn't be asked. So sometimes that's on past persecution. So sometimes, for example, family members know already, they discovered it. So you can't go back in the closet. Sometimes it is because people perceive them to be LGBT, rightly or wrongly. I had one Algerian client by coincidence who tried to conceal his sexuality, but everywhere he went, people would say, you're gay, and would literally beat him up. So yeah, it's a very dangerous place to be. There was a recent case here called YD, where it wasn't an appeal against the OO Algeria case, but they were considering OO Algeria. But what they argued in that case, and it was one of the same barristers that was in HJ, but what they argued in that case was that the very act of concealment is persecution. Unfortunately, the UK courts didn't buy that. But I think what Trish is saying perhaps is that, I would certainly like to think that in the future we could say, well, the very act of concealment is a dangerous place to be, and is persecution.
Thanks, Alan. Thank you all for joining us this evening. As I said, really important topic, a very powerful contribution from Alan, hard to listen to at times, but so vital that we make space to kind of educate ourselves about this topic. I'm going to end with my favorite sign off from the podcast Freakonomics, which is take care of yourself, and if you can, somebody else. Thank you, Alan. Have a good evening, everybody else. Bye-bye.
Thank you very much, Stephen.